Tonight, we begin with a development that immigration attorneys, policy experts, and applicants across America had feared, anticipated, and warned about for months. A decision that unfolded not over years of debate, but in a single policy memo. A single memo that left hundreds of thousands of green card applicants in limbo. A single memo that froze dreams of permanent residency. A single memo that changed the future for families who had waited years, sometimes decades, for this moment. What USCIS did today crossed a line that immigration advocates had hoped would hold. And when that line broke, the immigrant community did not hesitate. They responded with outrage, legal mobilization, and an immediate call to action. For several months now, there had been signals, not official announcements, not formal policy briefs, just signals, that the administration was preparing something unprecedented. USCIS has been overwhelmed, yes, but they have been strategic in their overwhelm. Their processing delays have followed a certain pattern, a rhythm, almost a predictability. But what set off alarm bells in Washington this week was that the pattern went silent. Immigration attorneys who monitor USCIS processing times know the indicators. The sudden halt in interview scheduling, the unexplained return of properly filed applications, the freezing of biometrics appointments, the sudden absence of approval notices. All of that went quiet. And whenever USCIS goes quiet, it means something is about to get loud. For years, applicants have navigated an increasingly complex system. They've filed their I-485 forms, paid their fees, sometimes exceeding $2,000 per applicant, attended their biometrics appointments, and waited. Some have waited 18 months. Some have waited 3 years. Some have waited even longer. And throughout that wait, there was always one comfort. The process, however slow, was moving forward. Tonight, that comfort has been shattered. Early this morning, immigration policy analysts detected what they described as an internal USCIS directive, including language about processing prioritization adjustments that had not been used in over 15 years. These are the kinds of administrative maneuvers that USCIS only implements when they are signaling something very specific: a temporary pause, a permanent policy shift, or a complete program overhaul. Observers didn't know which category this fell into, or whether it fell into all three at once. But what they did know was that USCIS was changing its posture on adjustment of status. And when a federal agency shifts posture without explanation, even by the smallest measure, every immigration attorney in America pays attention. The confirmation came at approximately 2:47 p.m. Eastern Time. USCIS released a statement confirming that adjustment of status processing would be temporarily paused beginning in the first quarter of 2026. The stated reason? Operational restructuring to enhance processing efficiency and ensure system integrity. But immigration experts immediately recognized this language for what it was: bureaucratic cover for a policy-driven decision. Operational restructuring doesn't pause an entire category of immigration processing. Policy decisions do. The response issued by immigration advocacy groups tonight was not normal. It was not routine. It was not symbolic. It was urgent. Attorney after attorney, organization after organization described USCIS's move as devastating, unprecedented in modern immigration history. And perhaps most importantly, legally questionable under existing administrative procedure requirements. But bureaucratic maneuvering only works if the affected community hesitates. The immigrant community did not. In fact, their response today was among the most coordinated and immediate we've seen in the immigration advocacy space. Here's what we know. Within 3 hours of the announcement, the American Immigration Lawyers Association issued a formal statement condemning the pause. These weren't the standard expressions of concern. These were emergency legal strategy sessions, the kind of mobilization that immigration advocates only deploy when they are preparing to file federal lawsuits. multiple immigrant rights organizations announced they would be seeking immediate injunctive relief. Pro bono legal networks activated their emergency response protocols. Congressional offices were flooded with calls. The response was swift, organized, and unequivocal. Tonight, sources within the immigration law community confirmed that USCIS's pause would affect adjustment of status applications across multiple categories, including employment-based applicants who had recently received their priority date advancement for what analysts believe was strategic timing. The pause will halt processing before thousands of applicants could complete their interviews. It affects EB-2 applicants. It affects EB-3 applicants. It affects family-based applicants who were finally approaching the front of a decades-long line. In other words, USCIS targeted the final step before permanent residency, the component that would have made years of waiting finally worth it. This is what made the announcement so devastating. USCIS's pause wasn't just administrative, it was consequential. It represented the kind of move that could derail hundreds of thousands of immigration cases if left unchallenged. And immigration advocates, understanding that fully, responded with legal force. Not recklessly, not impulsively, but strategically. They didn't issue empty statements. They didn't wait for further clarification. They filed emergency motions. They contacted every congressional ally. They organized affected applicants into plaintiff classes. They prepared for litigation. And here's where the story becomes even more troubling. Policy analysts now believe that USCIS's latest move was designed to test the resilience of immigrant communities after years of processing backlogs and administrative fatigue. USCIS wanted to see whether applicants would simply accept another delay. But instead, the opposite happened. Advocacy organizations didn't accept it. They launched a response that was so immediate, so coordinated, that even USCIS officials noticed. You don't get the federal government's attention easily. But today, immigration advocates did. Immigration attorneys, speaking with media outlets under anonymity, described USCIS's shift as strategic exhaustion, a way to discourage applicants from continuing their pursuit of permanent residency. But advocates proved today that they remain both vigilant and prepared. Their legal filings were not only comprehensive, they were timed so precisely that the first motion reached federal court before USCIS's business day had even ended. That timing matters because it shows preparedness. It shows that the immigrant community is not a passive victim of policy changes. They are active participants in their own legal defense. As reports continued coming in throughout the evening, we learned more about the scale of USCIS's decision. Employment-based applicants faced an immediate freeze, affecting an estimated 400,000 pending cases. Family-based applicants who had been waiting since before 2015 saw their interviews canceled indefinitely. DACA recipients pursuing adjustment of status through marriage found their applications returned without processing. This wasn't just a slowdown. This wasn't just a backlog. This was a full stop. This was an administrative blockade. And administrative blockades are the one thing immigrant communities have struggled to overcome since the beginning of increased enforcement priorities. For every step forward they have made, policy changes have countered with something that pushes them back. Remember, USCIS leadership thought applicants would simply wait longer. They thought advocacy organizations were too fragmented to respond. They thought congressional attention had shifted to other priorities. But tonight, the exact opposite is happening. Applicants are organizing. Advocacy organizations are unified. Congressional allies are demanding answers. The assumption that immigrant communities would quietly accept this pause has proven catastrophically wrong. What makes this moment so critical and so volatile is that USCIS's latest move happened at a time when the administration is under enormous political pressure. Restrictionist factions want fewer green cards issued. Business interests want more employment-based immigration. Humanitarian advocates want family reunification prioritized. Budget analysts want processing efficiency. USCIS leadership is balancing these demands while facing an unprecedented backlog crisis. And when agencies in that position make sudden moves, they're not doing it from strength. They're doing it from pressure. They're doing it from political calculation. They're doing it because someone, somewhere, decided that pausing adjustment of status was more beneficial than processing it. USCIS's statement, now circulating across every immigration news outlet, was designed to signal that the agency is prioritizing system integrity over speed. Officials said plainly that current processing volumes were inconsistent with available adjudication resources. That is bureaucratic language for, "We've decided to stop processing your applications, and we're calling it efficiency." You don't usually hear that kind of justification from USCIS unless something political is at stake. When federal agencies cite integrity and resources in the same sentence, experienced advocates know to look deeper, because those words are often cover for policy decisions that wouldn't survive public scrutiny if stated plainly. Meanwhile, leading immigration advocates addressed affected communities in clear, direct terms tonight. One prominent attorney said, "This pause is not about efficiency, it's about politics." Another said, "Every day this pause continues, families remain separated, workers remain in limbo, and dreams remain frozen." And a coalition spokesperson said, "We will fight this in every courtroom, in every congressional hearing, and in every public forum available to us." These are not rhetorical flourishes. These are statements from a community that understands just how high the stakes have become. Here's what makes the situation even more concerning. USCIS's latest move wasn't isolated. Along with the adjustment of status pause, DAS also announced reduced visa appointment availability at consulates worldwide. ICE increased enforcement priorities in sensitive locations. CBP tightened entry requirements for visa holders at ports of entry. All of this happened within the same policy quarter. When multiple agencies move simultaneously, it means something larger is underway. It means coordination. It means strategy. It means immigrant communities face pressure from every direction at once. Analysts are now considering several possibilities. One is that USCIS is preparing for a complete overhaul of the adjustment of status process. Another is that USCIS is attempting to reduce green card issuance without formally announcing a policy change. A third possibility, the one worrying advocates the most, is that USCIS is attempting to create such significant backlogs that applicants simply give up. But today, immigration advocates took that card off the table. They didn't wait for clarification. They didn't accept the stated justification. They didn't request polite meetings with agency officials. They mobilized. They filed. They fought. What we're watching now is a test of resilience. USCIS wants to see whether policy fatigue will defeat immigrant communities. Advocates want to show that legal resistance remains strong. Congressional allies want to prevent a permanent policy shift. And affected applicants want to prevent their years of waiting from becoming meaningless. This is not just about processing times. This is about whether immigrant communities have the stamina to fight indefinitely. Tonight, we've heard from immigration attorneys who are now monitoring USCIS's internal communications. They say the pause may extend beyond the initial 2026 timeline. They say affected categories may expand to include additional visa classifications. And they say USCIS's decision to announce this now is likely part of a broader strategy intended to reshape legal immigration entirely. But advocates are not retreating. In fact, advocates are escalating. Their response today, immediate, coordinated, and legally aggressive, sent a message to USCIS that affected communities will not be silent. And it sent a message to Congress that oversight is urgently needed. As the coming weeks unfold, We expect more details to emerge about what exactly USCIS hoped to achieve. But what we do know is that the advocacy community's response was timely. It prevented the pause from going unchallenged. It created immediate legal pressure, and it ensured that this decision will face scrutiny at the highest levels. What happens next will depend on what USCIS does in the next 60 days. If they reverse course, this moment will be remembered as a failed attempt at policy manipulation. If they proceed, immigration advocates have already shown they are prepared. They have shown they are organized. They have shown they are ready to respond. And tonight, for the first time in years, USCIS appears to be reconsidering. Washington is quiet. Too quiet. And when federal agencies are quiet after backlash, it means they are recalculating. It means they are choosing their next move carefully. Because tonight, USCIS learned something they should have already known. Immigrant communities do not surrender. Advocacy organizations do not tire. And legal resistance does not fade. This story is far from over. But tonight, one thing is clear. The pause has been challenged. The fight has begun, and the immigrant community will not be silenced. And we will be here, watching every detail as the next phase unfolds.